And now we're going to get into our next session. We are being joined by Chuck James and Chris Skinner. Their session will cover government investigation trends and corporate compliance best practices. Chris focuses his practice on international trade, including export controls, customs regulation, economic sanctions programs, trade remedy actions, anti-corruption, and trade compliance programs and counseling. I can only imagine he's been busy with all of the things going on with the supply chain these days. Chuck is a co-chair of our white collar and investigations practice and firearms industry group. He is a litigation partner who represents a diverse group of clients with matters before state and federal investigative bodies. Welcome, Chuck and Chris.
Thank you. Thank you, Jen, and thanks everyone for joining us today for what we hope will be a thought-provoking and useful update on government investigations, regulatory enforcement, and corporate compliance. Chuck and I spend much of our time counseling clients in each of these broad areas, but often in very different substantive areas and in different aspects of the laws in these areas. As you might have gathered from the introduction, my focus is on international trade and compliance, while Chuck is a litigator and former prosecutor focusing on white-collar matters and investigations. So when we do get to collaborate on matters, it's typically under some very serious circumstances for our clients. So over the next hour, we'll first offer an update on trends in government investigations and enforcement viewed through this lens of international trade regulation. Trade is a particularly useful environment for examining these issues because of the volume of enforcement actions and investigations, the extreme cost of violations to U.S. companies, and the real impact that neglect and non-compliance can have on U.S. companies in these areas. It's also an environment, as referenced, that has grabbed a lot of headlines lately, showing itself as an enforcement priority for regulators and increasingly as a tool in larger foreign policy or national security initiatives. So once we've reviewed some of the recent trends, we'll examine a few case studies and enforcement actions and explore what lessons can be learned from them and best practices that are more generally applicable to virtually all U.S. companies that operate in regulated industries. Next slide. So to set the stage a little bit here, first we're going to have a little bit of an overview, an examination of U.S. export controls and sanctions regulations. Now, I have a full day version of this presentation, a 3-hour version and a 1-hour version, at least of this part of the presentation. I'm sure for most of you, you'll be relieved to know that I've condensed this down to just a couple of minutes, reluctantly, I should say. But let's just set the stage for these regulatory areas. We tend to think of these as the 3 pillars of export controls: the ITAR, or International Traffic in Arms Regulations, the EAR, or Export Administration Regulations, there in that center column, and the OFAC Sanctions Regulations on the right. The ITAR regulates, as it sounds, defense articles. It's administered by the Directorate of Defense Trade Controls at the State Department. The EAR, the Export Administration Regulations, are administered by the Commerce Department in the Bureau of Industry and Security. And it's kind of interesting. It's sometimes referred to as the dual use set of regulations, but it's really a combination or salable of a few different set of rules and regulations. It includes the 4 primary multilateral export control regimes: the Wassenaar Arrangement for National Security Controlled Items, the Nuclear Suppliers Group, the Australia Group, and the Missile Technology Control Regime. But it also includes controls on lots of other things, some unilateral controls that are just strictly US only controlled items. And then finally, the economic sanctions regulations and executive orders that are administered by the Office of Foreign Assets Control restrict certain transactions with prohibited parties. They restrict transactions with embargoed countries, and in some cases, some sanction sectors of particular countries. Next slide, please. Now, to understand enforcement in these regulated areas, one must really appreciate the range of possible violations that can occur. These are just a few in this slide here under the ITAR and the EAR. Broadly speaking, under these export control laws, we're concerned with unauthorized or unlicensed exports or re-exports or transfers in country of items that are controlled for a particular reason to a country that requires a license for those things. But these laws also have violations for things like releasing controlled technology or technical data, even if that release occurs in the United States to a foreign person. It's called a deemed export. It's deemed to be an export to that foreign person's home country. Other kinds of violations include exports and re-exports and transfers to prohibited end uses or end users or destinations. And that can include for things that aren't controlled for any particular reason or sensitivity. They're just being exported to one of these prohibited parties or end uses, such as nuclear end uses, chemical or biological weapons, proliferation end uses, or missile end uses. You can have violations for false statements in export documentation. Under the EAR, it is a violation to proceed with any transaction with knowledge that a violation of the EAR has occurred or is about to occur or will occur in connection with that transaction or that item. And then you have those sort of inchoate violations as well, the causing, aiding, or abetting a violation or conspiring to violate these laws. Next slide, please. Now, the sanctions programs dovetail in a lot of ways with the export control regimes, the ITAR and the EAR, but they include some additional violations as well. We've seen this expand in recent years to have taken on new importance as a tool for countering bad actors or to furthering foreign policy or national security interests. In addition to prohibited exports to destinations, embargoed countries, we have under the sanctions regulations prohibitions on imports from sanctioned parties or sanctioned countries, dealing in property or property interests of a sanctioned party. Now that's extremely broad, but that's a reference to that specially designated nationals list, that bad actor list that's maintained by OFAC. In fact, is updated on a virtually daily basis. We have exports and re-exports for sale or supply of any goods to a person in a third country if you know, if this US person knows that the party in the third country that purchased them is going to divert them or re-export them to a prohibited end user or prohibited country. And then US persons can also violate the sanctions by facilitating a transaction by someone in a third country who's not subject to the regulations directly, but that would nevertheless violate the sanctions laws if performed by a US person. Those kinds of facilitation violations come up where you're diverting business opportunities to offshore because you couldn't engage in them yourself, and so a few other circumstances as well. Now, increasingly today, we're seeing the sanctions regulations also being applied against non-US persons, presumably, and in some cases for transactions that don't really have much of a US nexus. So non-US persons can violate the sanctions by causing a US person to violate the sanctions. We'll talk about that in a little greater detail later on. Or by evading or avoiding the sanctions, doing things that disguise a transaction that would be caught as a violation. And then these things called secondary sanctions, which are some penalties imposed on non-US persons for engaging in significant transaction with sanctioned parties overseas or with targeted sectors of foreign economies. You can think of, for example, the Iranian oil and gas sectors or the Russian intelligence and military sectors. Next slide. So anyone familiar with the export control laws or who pays attention to the enforcement press releases that are published regularly, you know that the consequences for violations can be quite severe. Depending on the activity, most civil violations are subject to strict liability, but some require knowledge, which includes reason to know of a high probability of the violating circumstances. Think of, for example, an export where there's reason to know that the recipient is going to re-export those goods to Iran or another prohibited destination or end user. Statutory civil monetary penalties for violations are in the hundreds of thousands of dollars, $1 million per violation in the case of the ITAR. And it should be noted that a single transaction almost can result in more than one violation. There's almost never just one violation in an export enforcement action. A single unlicensed export, for example, you have the violation for not having the license that's required for the transaction. You most likely have a violation in the record-keeping provisions of the rules, and you also have a violation in whatever statements you made in your export declaration that were most likely incorrect about that transaction. So these things can very quickly add up and compound. And there are potential criminal penalties for willful violations. And these can be up to $1 million per violation, for individuals up to 20 years imprisonment. A willful violation, of course, is committed with knowledge that it was prohibited by law or done with in disregard for a known legal obligation. But equally important for exporters in particular are these other administrative penalties for violations, things like denial of export privileges or suspension or revocation of licenses. And of course, the damage to reputation that might come from a public announcement about your settlement or your enforcement action, and the cost and distraction of an investigation, whether that be an internal investigation done by the company itself, or one directed or performed by the Directorate of Defense Trade Controls or one of the other agencies. Next slide. All right, so the Foreign Corrupt Practices Act, or FCPA, is another area with a nasty combination of high risk, active enforcement, and high value penalties for US companies that are engaged in international trade. The FCPA is divided really into two parts. It's in some ways a 1-2 punch for enforcement because many violations have actions brought under both parts. So the FCPA's anti-bribery provisions are enforced by the DOJ's Criminal Division Fraud Section, and the accounting provisions are enforced by the SEC. As most know, the FCPA prohibits US companies from essentially paying bribes to foreign officials. But really what's often misunderstood is the scope and breadth of what is prohibited. This caption here in this view graph is close to the language that appears in the statute itself. So the anti-bribery provisions prohibit offering to pay, paying, promising to pay, or authorizing payment of money or anything of value to a foreign government official in order to influence an act or decision or to retain business, that kind of thing. And this doesn't have to be done by the US company itself. It can be done through an agent in country or another intermediary or distributor. Next slide, please. And in practice, one of the biggest areas of risk for US companies is their dealings with foreign distributors and agents in country, especially when they sell to foreign governments, militaries, or government-owned entities like hospitals, utilities, universities. This is particularly problematic in countries like China, where state-owned entities are prevalent. It's not always known by the US party that the company they're dealing with are ultimately selling to or even through a distributor or third party is a state-owned entity or a government-owned entity. So this is a high level of risk for US companies and exporters, particularly because there's a lack of transparency often in what your in-country agents are doing. And you're also relying on those third parties to expand into these new markets and use their expertise and connections to do so. So these are opportunities that are ripe for violations and unlawful bribes being paid. If the company's foreign agent, sales rep, or consultant makes one of these prohibited payments, it can be, US companies can be liable for that. They're prohibited for making payments to any other person while knowing that the funds will be paid to the government official. And what the US government is going to look at when they investigate is what sort of procedures did the US company have in place to prohibit these kinds of payments? And what did the company do to respond to red flags? Was there willful blindness? These are all circumstances where they can easily find knowledge on behalf of the US person. Okay, next slide. And of course, the penalties under the FCPA are very severe. Criminal fines up to $2 million. Often we're looking at disgorgement of gains from these non-US arrangements. For individuals, there are criminal penalties of up to 5 years imprisonment, $250,000 per violation, or 2 times the gain or loss, and civil monetary penalties of up to $100,000 per violation. Recall also that there are separate penalties for accounting provisions and violations, and actions are often brought these days against the company, the individuals within the company who are directly involved in the activities, and increasingly senior officers and directors, depending on what their knowledge was of the circumstances. And that, I believe, brings us to our first polling question.
Yeah, thanks, Chris. And so now we have an opportunity for some audience participation. For those of you who were with us in earlier sessions, you know how to do this. Please go ahead and indicate your response there in the chat. I see folks are already doing that. The question, of course, is on a scale from 1 to 10, how important is anti-corruption and international trade compliance to your overall business? Again, scale from 1 to 10. And I'm seeing answers fly in, and I think we have covered every number from 1 to 10 in the comments here.
There are quite a few 10s there, and I think we might have biased the field here.
Yeah, absolutely. Yeah, we are definitely tipping our hand, as Chris and I would certainly urge all of our in-house and outside counsel colleagues to make this a priority for the reasons that Chris has touched on and that we'll get to here very shortly. For those of you who did make it as a priority, say those 7, 8, 9, just so you know sort of how you stack up. In 2020, the Association of Corporate Counsel asked a variation of this question and gave about 1,000, just over 1,000 chief legal officers and general counsels an opportunity to answer variations of this question, and their answers were interesting. Again, on the same 1 to 10 scale, those 1,000 CLOs gave regulation and compliance an average score of 8.12. They gave general enforcement and investigations a 6.03 on average. Corruption and bribery, very closely related, of course, came in at a score of 5.10. And then some other issues, whistleblower issues at 4.66, and sanction and export controls at 4.25. So regulation and compliance are certainly very high generally, but I was pleased to see how much of a priority so many of our colleagues put on some of these other subsidiary issues, very important, but more niche issues within the regulatory and compliance fields. So we'd be glad to chat with you about those things offline, but clearly we think this is a very important topic. Chris?
Thanks, Chuck. So I'd like to turn now to some enforcement data that I've collected, and I don't include these data for their shock value, although some of them are really pretty shocking, and they're not comprehensive, but instead what I've done is sort of selected out, cherry-picked some data that I think tell some interesting stories about enforcement and investigations, at least within the last decade or so, and in comparison to how these laws were enforced previously. But I think they're helpful for a variety of reasons, but one of which being allocating compliance resources to high-risk areas and looking at what regulators are doing these days in these areas. So under the EAR, the Export Administration Regulations, this is the Commerce Department regulations on exports, we see a pretty consistent amount of enforcement actions over the last 5 years or so. But when you zoom out a little bit, you see a few trends, things like increased prison sentences for individuals convicted of criminal violations in these areas, and much higher civil monetary penalties for violations. So for example, in 2005, which was a fairly typical enforcement year in that decade, it registered civil monetary penalties of $6.8 million total, which is easily eclipsed by each of the last 5 years, and in fact, even fiscal year 2021 to date. I'd highlight also this bottom row under the enforcement statistics for administrative actions under the EAR. You notice right around 500 of these warning letters being issued. That's an indication of the number of investigations that have been undertaken during that calendar year. And it's an indication really of the amount of directed and voluntary self-disclosures, because these are investigations that were undertaken, cases that were opened, but resolved without issuing a monetary penalty or an administrative penalty like the loss or suspension of export privileges. So a lot of those instances are being looked at, examined, and then closed with a warning letter for exporters, which is, good news for sure, but just gives you a sense for the volume of these things. And that's really important when we talk about disclosures a little bit later. So next slide. Now, under the ITAR, our regulation of defense articles, data are somewhat a little bit more scarce, and many investigations are resolved with DOJ and DDTC with the party privately, and there's not a corresponding press release. That's not always the case, but sometimes. Generally speaking, under the ITAR, the number of cases resulting in monetary penalties tends to be less, but we tend to see higher dollar values in these penalties. And you can see from this list here, this is a list of consent agreements that DDTC has entered for your more serious cases over the last 5 years or so. They tend to get to about 2 of those per year, some years more, some years less. But these consent agreements are very extensive. And often include not just that monetary penalty, but some other things like auditing requirements or requirements to have an in-house monitor that's a third party that's going to be looking at your compliance program and reporting back to DDTC on a periodic basis about compliance measures and about exports. Another interesting fact from DDTC is how many disclosures, voluntary and directed disclosures that they process. So this past year, we're looking at around 700 voluntary or directed disclosures per year. That's down from a high in 2014 of around 2,000. And for those trade and export control wonks among us, I'd certainly include myself in that list. You'll recognize that as the time period when export control reform went into effect, when they started changing the regulations to move some of these military defense articles from the jurisdiction of the ITAR over to the Commerce Department regulations under the EAR. And so those enforcement actions sort of go with it, and so do those voluntary disclosures. So you see that number coming down, pretty sharply over the last almost a decade or so. So next slide. OFAC sanctions violations too, we've seen a real boost in the last decade versus the period that came before it. This is a listing of some of the aggregation of the civil cases and settlements. You see some really astounding numbers here. These are largely skewed by these bank cases that OFAC has brought against non-US financial institutions. And the common theme in these cases is that cause of action I described before about the kind of violation where a non-US party causes a US party to unwittingly violate the sanctions. There are a number of ways this can happen, but in the bank cases, what the banks, some of these foreign banks had done was strip out identifying information in electronic bank, wire transfers and other electronic transactions that went through the US financial system, so that US dollar transactions were processed by US banks on behalf of sanctioned parties and sanctioned countries, and they didn't know it because that information wasn't included in the SWIFT transfers or other wire transfers that process those transactions. And so we got these really inflated enforcement numbers. Next slide. FCPA 2 has seen some dramatic increase in enforcement since right around 2007. If you compare enforcement in the 1977 to 2005 period, 1977 being the year of enactment of the FCPA, we had only about 3 to 4 cases per year during that 30+ year period, and the penalties themselves amounted, even over that entire period, to only about $190 million. Now that is, of course, easily eclipsed today by any given year, really, except 2015, I guess, being an exception there. But easily seeing penalties now in the billions. And if you look at the next slide, where we see some of your higher ranking FCPA actions that really ended up in the billions. For a long time, that Siemens case, that $800 million settlement, was the leader of the pack, and it was recently displaced in 2016 by the Airbus and then Odebrecht cases. So next slide. Now, zooming out a little bit, we can see some some trends here that are really the through lines from an enforcement investigation in these areas. And so what's contributing, to these increases in all these different categories of enforcement data? Well, when you look at these at a high level, there are really a few different answers. We have increasing international cooperation in investigations. That's one factor. This is particularly prevalent in the FCPA area. But even in export controls, in 2010, there was an EU mutual legal assistance and extradition agreement that increased the sharing of resources. Also, we rely more and more today on what they call the Blue Lantern program, which are pre and post export licensing checks that are happening all over the world by the US government through, in some cases, our embassies in country to verify the bona fides of transactions that are subject to export licensing. We also see greater extraterritorial reach of US trade laws in a few different areas, greater obligations of US companies to conduct thorough due diligence on their foreign business partners. And this is one that's kind of interesting, particularly in the area of restricted party screening, which is a really important keystone and for your compliance program when you deal in international transactions, to have a way to ensure that the companies and parties you're dealing with are not on a restricted party list. And this is more complicated today than ever. One, because there are a number of different lists that are maintained by each of the agencies. The lists are changing all the time. There's not a day goes by that I don't get some announcement in my email box from OFAC indicating a change to the specially designated nationals list, for instance. And also under the OFAC regulations, there's this thing known as the 50% rule, where a specially designated national, a prohibited party, is deemed to include any entity that is owned by 50% or more by one or more SDNs, even if they're not on the list themselves. So that, imposes some real requirements on US companies to understand not just the company they're dealing with, but whether or not, the ownership of that company, whether they're owned by an SDN or, more than one SDN in some cases. And if you look at those lists today, they also include things like foreign language names of parties, which is a little bit difficult to screen for in some cases. Famously, a few years ago, there was a case brought against Amazon for some exports to Iran, but not the country of Iran. They were exports to the embassies, the Iranian embassies located in other countries, and Amazon was delivering product to those embassies. In addition, there are expectations that U.S. companies engaging in international transactions have appropriate risk-based compliance programs. I mean, that's a common theme we see in consent agreements these days, a real examination of their compliance programs and an indication of where they're lacking in certain areas. We see a dramatic increase, of course, in enforcement actions and the dollar values, greater prosecution of individuals that are involved in particularly corruption schemes, but also in the export controls world, and continuing rewards for companies that voluntarily disclose suspected violations.
Chris, let me make a couple points real quick on this as it relates to some of the domestic issues. We're focusing here, and Chris's expertise is particularly in the international arena. But I want to stress to those of you who maybe answered to our first audience participation question a 0, a 1, or a 2, who don't have export control exposure or don't think you have export control exposure. If you're in a regulated industry, you're going to have some of these same considerations. Assuming you have no extraterritorial business, some of these hallmarks and the enforcement trends are very much present in domestic law enforcement and regulatory fields. Those include things like an increased emphasis on self-reporting, an increased emphasis on having an internal compliance plan and sticking to that. There's certainly been a series of memos that have come out from the Department of Justice purely for US law enforcement for domestic activities that are holding more and more individuals accountable for the acts that they participate in, and less of an emphasis on simply letting the company, for lack of a better term, take the fall. So even if you're entirely focused on domestic activities, a lot of these are hallmarks of domestic actions, and we'll talk a little bit more about that as we move forward.
All right, next slide, please. So I just wanted to take a couple of moments to dig a little bit deeper into the export control sanctions trends and put a little finer point on some of those. items. So increased extraterritorial reach. We talked about targeting non-US companies and non-US subsidiaries of US companies and how they're dealing with particularly US origin goods. There are today more restrictions and more complicated restrictions on what can happen with US products after they leave the United States. We have enforcement and regulations dealing with the incorporation of US content into foreign-made products and whether or not those foreign-made products are going to be subject to US export controls. This thing known as the de minimis rules looks at the value of the US content and whether or not it's such that that foreign-made item is going to need to be subject to controls, which then becomes a violation if re-exported or exported by that foreign producer of the item. We have the foreign direct product rule, which controls certain items that are made from US technology or technical data or US software. And Huawei, which has captured a lot of headlines in the last few years, has its own foreign direct product rule that expands on that rule that restricts certain, particularly semiconductor technology and items made from US origin semiconductor technology for export to Huawei. And that doesn't apply just to US parties, it applies to the foreign parties that are making things from that US technology. And there's increased onus on US exporters, as I mentioned, to know their customers. Another example of that under the export control laws is this recently expanded military end use and end user rule that now applies to Venezuela, China, and Russia, where there is a prohibition on exporting certain US items to a military end use or military end user in any of those countries. And those terms are defined extremely broadly and often leave exporters without really knowing whether or not the end user is a company in one of those countries that has previously been engaged in military type activities. Next slide. And similarly, under this economic sanctions laws, this notion of causing a violation extends extraterritorially to non-US parties and evading and avoiding the sanctions. And we talked about secondary sanctions, which imposes on non-US companies prohibitions on things like access to the US banking system, prohibitions on access to US government contracting or World Bank contracts for dealing in certain transactions with sanctioned parties overseas or with those sanctioned sectors of foreign economies like the Russian oil and gas sector, the Russian military and intelligence sector, the Iranian oil sector, or automotive sector. Next slide.
All right. So let's talk a little bit about what I'll call the other side of the coin. Chris has talked and helped us understand FCPA, that is exposure for US companies and individuals when acting in foreign countries. This is in some ways the flip side of the same coin. That is to say, what is the exposure for a US citizen, a US entity, when they are doing business in the United States and interfacing with the federal government on behalf of a foreign entity? So by way of background, FARA, as we'll call it, the Foreign Agents Registration Act, goes way back to 1938 and has some geopolitical origins, but really was not particularly robust in its enforcement for quite a long time here. We saw a lack of prosecutions and enforcement actions for years, but it's really come back on very strong here in the last several years, in part thanks to an office of the Inspector General, that is the DOJ Inspector General, issuing a report saying that, frankly, FARA enforcement actions had been lacking. So combine that where the DOJ FARA section sort of had its feet held to the fire, combine that with the 2 election cycles ago, we have a new incoming president. We have a lot of folks who were trying to trade on their sphere of influence. We had an uptick in the number of these prosecutions, many of which stemmed from the Mueller investigation that we may be familiar with. So what does the FARA actually do? Well, as you can see, it requires certain agents of foreign principals who are engaged in political activity or other activities that are all specified into the statute to make a periodic disclosure of their activities. Now, that requires a number of things. First, They have to have some foreign actor, typically a government entity or someone who's acting on behalf of a foreign government. It requires first it requires them to register. So once a US citizen takes on this role, you have to register with FARA, and there's an application and a form that you fill out to say, I, John Doe, am going to be representing the interests of country B, and you have to disclose that. You even have to disclose your contract, which in many cases will make it public information, or at least available to the Department of Justice, how much you're being compensated. And then there are a series of other requirements, things like you have to have, in addition to the initial disclosure, disclose every 6 months any changes to your status and your scope of work. You have to disclose the contract, as I said. Even publications, whether they be press statements, op-eds, letters to the editor, to the extent they're drafted by a covered party, an American citizen, those have to be disclosed to the Department of Justice within 48 hours of publication. And you also have to maintain those records for a period of 3 years. All of this is monitored, enforced, and regulated by what had been a relatively unknown unit within the National Security Division at the Department of Justice, that FARA unit. It's a subset of the counterintelligence and the export control section of the National Security Division, and they're responsible for this. And they've beefed up their headcount in recent years, and they really have flexed their muscles. And we'll talk about some of those cases. Next slide, please. So a couple of examples borrowed quite liberally from some DOJ training materials are here. That is to say, here's a fact pattern, and we'll start identifying some issues. Example 1, prominent business leader schedules an appointment to discuss energy policy. However, upon showing up, they don't discuss energy policy, and instead they engage in an unrelated topic, and we'll say here, country A's image within the United States. And then during that discussion, this prominent business leader, again, with whom you thought you were going to be discussing energy policy, makes a series of statements that sound eerily like some statements you may have heard from a foreign government. Well, those are all red flags if you're in that meeting. There are a number of things there. First is, of course, the okey doke, if you will, the switch that this business leader has pulled on you. If you're expecting a meeting on one thing and it switches to something else, and as you hear the comments, you feel as though you're being lobbied, advocated. They're talking as if they represent someone other than themselves, and those interests are aligned with a foreign entity. It would be incumbent upon you, if not prudent, if not incumbent, to ask them further questions. In the example 2, somewhat related, a lobbyist in this case requests a meeting to discuss telecommunications. But when they arrive, she's not alone or with her normal assistants or colleagues or partners, what have you. Instead, she's accompanied by members of a foreign government or a foreign political party. And having made some brief introductions, you find that the meeting is really not so much led by the lobbyist, with whom you may have a long-standing relationship, but in fact, the talking is being done by those foreign dignitaries, those foreign officials. And they're highlighting issues that are significant to their relationship with the United States. And this is not an all too uncommon experience. The closer you are to the Beltway, to DC, and so some of these regulated entities and to Congress, it's going to be certainly more common than it might be in some other places. But again, the red flags that should go off here are going to be the role, whether they're in the room or they're a talking head behind the scenes, really speaking to you and seeking some sort of access, some sort of advocacy on behalf of a foreign country. Next slide, please. So a couple of these that have come up before, we'll note just a couple of them. First one is Elliot Brody. Now, Elliot Brody, prior to being charged, was a prominent fundraiser. He had his own business interests, but he was a prominent player and traded on that access as a fundraiser at the RNC and some other places to leverage that to influence certain federal government officials. And in this case, what he was ultimately charged with was working on behalf of a foreign entity, specifically in helping to get the Department of Justice to drop what it was at the time an ongoing investigation of the 1MDB syndicate. That's both references an individual who was sort of the principal there, but a Malaysian syndicate that was engaged in all forms of money laundering. And Brody was actually successful in getting some meetings and attempting to sway the Department of Justice to change their course. Now, as the story unfolds, one, the Department of Justice ultimately was not swayed, and they did pursue the very charges against 1MDB. Two, Elliot Brody was approached and ultimately charged and convicted, and before he was ultimately pardoned by President Trump at the very end of his administration. It didn't get as much attention as did Paul Manafort, but certainly that's the one that most people are aware of. If they're aware of anything in the FARA world, it's those charges that came out of the Mueller investigation. There were a number of them, most notably Paul Manafort. Now, in his case, he actually pleaded guilty to 2 counts, the first being a conspiracy to commit multiple offenses, including FARA, by failing to register. Now, in Paul Manafort's case, he at all times was working on behalf of the Ukrainian government. They had certain interests that they were trying to advance. They felt like a change of the administration, that they had an opportunity here. There had been some issues between Ukraine and Russia at the end of the Obama administration, and they seized what they thought was an opportunity. And for them, getting into Paul Manafort was someone who could help turn heads and influence policy at the highest levels in the United States. Paul Manafort's problem, though, was that he failed to disclose this. There are mechanisms under FARA, as we've talked about, with registration and disclosure and all the rest where he could have done these things, but he failed to do those things. And really what FARA is trying to get at is making sure that all parties who are engaged with one of these individuals, if you're engaged with Paul Manafort, you know that in fact he's working as an advocate. Just as Chris or I would certainly be working with a government agency, they know we're working for a client. They know that we're working on behalf of a specific entity. We would be disclosing that to them, and they know where our interests and our allegiances lie. The trouble here is that Mr. Manafort, Mr. Brody, and so many others who were prosecuted failed to disclose that. It causes a lack of transparency. It causes a lack of ability for a government actor to evaluate, is this really what this particular person believes and feels? And am I getting some advocacy from someone I know, like, and trust, and I have a relationship with, or are they a hired gun? In Paul Manafort's case, he ultimately failed to register as an agent of the Ukraine. And as you may recall, he was sentenced to 73 months of federal imprisonment before, in December of, I guess it's 2019, just at the end of the Trump administration, he was ultimately pardoned. Next. So we have our second audience participation. So switching gears from FARA and from FCPA, we just want to talk more broadly. This is going to apply to everyone, even if you don't believe you have an international footprint. Do you, as a company, have a fully implemented written break the glass procedure? And what we mean by that is a policy or procedure, what to do when a federal regulator comes to your office. A for yes and B for no. I'm seeing A's, I'm seeing B's, I'm seeing I have no idea. Those people should call us later. A little bit of both. Go ahead, Chris.
Just going to say, it looks pretty half and half.
It does look pretty half and half. A couple quick points on that. There is probably no point in most of my clients' existence, professional existence, or stress levels for me as an advocate than when I am on a call and my secretary, my legal assistant, my paralegal, one of my partners comes in ignores the sign on the door and that says I'm participating in a CLE and says, Chuck, we need you on the phone. The FBI is at Acme Company's place of business right now, attempting to execute a search warrant or to question an employee, and they're not sure what to do. Can you help us? And so what we advocate in these cases is have a plan. Know what you're going to do beforehand. Do that in your quiet moments. Do that to the extent you have a quiet moment. Do it when there's not a stress factor at play here, because clients frequently make mistakes in the heat of the moment. And to have a plan and to implement it will save you money in the long term. It'll prevent some very problematic missteps that many people make in these scenarios. And it'll save you having to break me out of a CLE or a presentation as happened to me just earlier this week. Chris, any other comments there?
No, that's it.
Okay. Let's go to the next slide.
All right, so now we'll take the last few minutes to look at a few recent enforcement actions in these areas and glean what we can from them. The first that I'll take here is Keysight Technologies, Inc. This is a consent agreement that was issued or entered into in August of this year, so not very old. The value of that consent agreement was a $6.6 million civil monetary penalty, $2.5 million of which was suspended to be used for cost of various compliance measures, things like having a compliance monitor, conducting a comprehensive classification review of all their hardware, software, tech data, and defense services. But what happened here, I like this case because it's kind of it has a lot of nuggets in it from a compliance perspective and really is a good segue to talk about voluntary self-disclosures and disclosures generally. So what happened, this company Keysight Technologies makes this really sophisticated software called Signal Studio for multi-emitter scenario generation software that has applications in electronic warfare, but also in testing things like radar equipment on fixed and mobile platforms. The company maintained that this software was not subject to the ITAR. It wasn't a defense article. It could be used in lots of different applications and had classified this as what's known as EAR 99, meaning it's subject to the Export Administration regulations, but not controlled for export, except to like embargoed countries or restricted parties, that kind of thing. And so they were on their merry way doing their business and get a call from DDTC asking about the classification of their software. We don't really know what intelligence DDTC had that the company was exporting their software, but in any event, they get an inquiry about it. And the company does two things in response to that inquiry. The first thing is to make what's known as an initial notice of voluntary self-disclosure, telling DDTC, look, we're filing this disclosure. We have exports of this software, but they didn't admit to any wrongdoing or violations in that disclosure. They instead did the second thing, which is to request what's known as a commodity jurisdiction ruling from the State Department to tell them what the classification of their software is, whether or not it is in fact a defense article subject to the ITAR. They ended up losing that, or I should say they got an unfavorable ruling in that classification determination, as DDTC said, no, this stuff is a defense article and it's prohibited for export everywhere in the world without an export license, or in some cases, a license exemption. And so they found and ultimately made a full voluntary self-disclosure of 24 violations resulting directly from the misclassification of this software. And as I mentioned, they had to a $6.6 million civil monetary penalty, which is not huge in the grand scheme of things from an ITAR perspective, but is somewhat large given the number of underlying violations. Next slide. And you can arrive at that number by looking, as the agencies do, at the mitigating and aggravating factors. Both DDTC and the BIS at the Commerce Department and OFAC, all three of these agencies have this kind of matrix of violations and penalties that assigns a base penalty based on the nature of the violation, and then they escalate or or de-escalate that penalty based on mitigating and aggravating factors and the weight of those factors based, on the particular facts of the case. Here, some mitigating factors. Well, there was a disclosure. Now, it's not really clear that that was a voluntary disclosure. Technically, under the regulations, you only get credit for a voluntary self-disclosure when the facts or circumstances of the violation are disclosed before an agency of the U.S. government has those facts in its possession already and brings that up to you. There were some remedial compliance measures that were inserted to deal with the circumstance once the classification issue was identified, and of course their cooperation with DDTC during this whole process. But there were also some aggravating factors here. As I mentioned, the disclosure is not quite voluntary. The initial disclosure didn't admit wrongdoing. And instead they filed a CJ and ultimately appealed that CJ ruling to a higher level because they still disagreed that it was an ITAR controlled piece of software. And this is what I think really put the bee in the bonnet of DDTC in this particular enforcement action, is that they continued to export the product while that CJ was pending. So you're waiting for a decision about whether or not your thing is controlled, but you're assuming it's not controlled and continuing to export it without a license. They could have gone in and gotten a license, even though they take the position that the thing is not controlled. And I think that, was a significant aggravating factor in this particular case. Also, we had exports, 15 out of the 24 violations were exports to China and Russia, which are arms embargoed countries. So that sort of ratchets up the national security concern. And as we're seeing more and more these days, this notion that an export of a physical good, a widget, has, some national security implications if it's controlled under the ITAR, but exporting the technology or the software to make that thing is viewed as far more serious because you, in some sense, enable the foreign recipient to make more of those things. So those are all aggravating factors that were taken into account here. Next slide, please. So what does this tell us about voluntary self-disclosure? Well, generally, they're not required. They're strongly encouraged by the agency, except in some cases they are required. There's always exceptions, right? Sometimes, in order to prevent additional violations, you need to secure a license for future transactions, but in doing so, you would reveal that you've already engaged in unlicensed transactions. So you might need to make a disclosure in that case. Also, sometimes an export violation, for example, to China or another country that's on this section 126.1 list in the ITAR has a compulsory disclosure requirement. Sometimes you're directed to make a disclosure by the agencies. And then I would also mention that under the government contracting regulations, in some circumstances under the federal acquisition regulations or defense federal acquisition regulations, disclosures are mandatory. They're part of that contract. Next slide, please. But in cases where your disclosure is in fact voluntary, there's a lot to consider in making the disclosure, and it's not always a slam dunk case for making the disclosure. Often it's a business decision, but there are a lot of different factors that go into that. They include things like the nature of the violation. Was it a one-time violation, or is there a potential for future violations? Was it a technical violation, or was it substantive? Something like a record-keeping requirement, or maybe a slightly incorrect statement in an export document. Something technical like that, some companies will opt not to disclose because there isn't a real national security impact. And then you have to consider, what sort of mitigation of penalties are going to come into play. And for some actions, not particularly in export controls, but sometimes in export controls, the possibility of a whistleblower action. We see this sometimes in the import context with duty evasion in imports. There's the possibility of an employee being involved in a key TAM action, a whistleblower action, because the US government has been deprived of monies that they were owed based on an incorrect duty assessment at the time of those customs entries. Or in the context of government contracting as well, some key TAM actions for things like False Claims Act violations. Next slide.
So just as Chris was describing there, the question of whether or not to self-report is often a critical one. And in some ways, the Walmart case, which I'm going to talk about ever so briefly, is an example of what happens sometimes when things go wrong, when that doesn't happen. So in that case, they settled their matter, as it notes here, a criminal penalty of $137 million plus an additional $144 million that was disgorged in a Securities and Exchange Commission civil action, all on top of more than $900 million they spent on the various investigations, internal investigations, outside counsel, and all the rest to resolve this 7-year affair. And at the core of what happened here is Walmart, as it branched out into other countries to include Brazil and China, India, and Mexico, hired a series of intermediaries who were in essentially business development functions. And those individuals then went out and paid bribes in these countries. And I would note, this is a bit of friction here because in many of the countries where American entities are operating, a culture of graft and corruption is normal. It is baked into society. And so to be clear, there's this friction between how do we do business to abide by American US law, and how do we operate in these countries where you can't get anything done without paying some of these bribes or fees and these special considerations to officers and officials of the government. Nevertheless, here's where Walmart found themselves, and perhaps intentionally, perhaps not, but by using these third parties, they were unable to escape liability. And interestingly, to the point of self-report, as you see here in the slide, there was no voluntary disclosure of the conduct in Mexico. That's what began the investigation. And once Walmart began digging into it, they became aware that the same pervasive conduct was happening in these other countries, and they reported that. They get some benefit for reporting that conduct, but not entirely, because it only came up in the context of unreported Mexican illegality. Next, please. So again, we want to step back and talk a little bit about things that are widely and broadly applicable. Let's assume you have no international footprint. Let's assume you operate in North Carolina and nowhere else. The following things are going to help you figure out how to get your arms around a situation. And so we have 4 keys to a good internal investigation, all of which come into play in these various FCPA, FARA, and other export control issues. One is you have to have an effective reporting mechanism. You have to have a way that an employee can raise an issue. You have to have a way that they can do that anonymously, because if it's not anonymous, they're going to be less incentivized. They're going to be more scared to bring something forward. And it's interesting, even whether it's in Virginia or under federal law, there have been some recent statutory changes that really do incentivize this. There are more and more opportunities for employees to bring claims both to their employer and as well as to the government, as well as protections for those whistleblowers. So having a system that's anonymous, that works, and that you take seriously and has some protections for these whistleblowers so that you can't go out and fire someone who raises a claim are all critical. Second, you want to have a properly scoped investigation. Some clients, particularly smaller clients, are incentivized to have any allegation of wrongdoing handled by HR. They treat a particular allegation like they might something like, say, a sexual assault, a sexual harassment claim. And that very well may be appropriate in some cases, but not in others. And so getting the right team involved is critical. And investigating it quickly and having the right resources and acting on that. And finally, tracking your results so that you can report them when and if you need to, and avail yourself of the benefits of a self-report. Next slide, please. A few more best practices, going to hit these very quickly. Ensure your employees know how to report, protect those whistleblowers, and once you've identified a problem, fix it. Find the remedial action, because nothing helps me as your advocate in these scenarios like being able to say, we found the problem, we fixed the problem, and it's not going to happen again in government. Next slide. And the last, audience participation. I think we'll have to skip that one. I do appreciate your time. Thank you, Chris, who showed great leadership in putting together the vast majority of this. Appreciate each of you for participating today, and we'll be glad to follow up with any of you that have any questions we couldn't address here. Thank you so much and have a great weekend.
Thanks, everyone.